Indian Constitution, Article 7. Citizenship of Migrants of Pakistan, Article 7. Under Article 7, a citizen by domicile, Article 5, or by migration, Article 6, ceases to be a citizen if he has migrated to Pakistan after 1st March 1947. An exception is, however, made in favor of a person who has returned to India on the basis of permit for resettlement in India. Such a person is entitled to become a citizen of India if he fulfills other conditions necessary for immigrants from Pakistan after 19 July 1948, under Article 6. He can register himself as citizen of India in the same manner as a person migrating from Pakistan after 19 July 1948. Article 7 thus overrides Articles 5 and 6. Both Articles 6 and 7 use the term migrated. The meaning of the term migrated came for consideration before the Supreme Court in Kulthi versus State of Kerala. According to the court, the term migrated used in Articles 6 and 7 has to be construed with reference to the context and purpose and the prevailing political condition at the time the Constitution was being enacted. So interpreted, the word migrated could mean nothing except voluntarily going from India to Pakistan permanently or temporarily. The majority held that the word migrate was used in a wider sense of moving from one country to another with the qualification that such movement was not for a short visit or for a special purpose. Thus, it is a question of fact whether a person has migrated to or has gone to Pakistan on a temporary visit only and has to be decided on the facts and circumstances of each case. Citizenship comes to an end only when there is a migration and not where there was only a temporary visit. But in the context of the Constitution, it has the notion of transference of allegiance from India to Pakistan. A temporary visit on business or otherwise cannot amount to migration. In State of Bihar versus Kumar Amar Singh, one Kumar Rani, who was admittedly born in the territory of India and claimed to be the lawfully wedded wife of an Indian citizen whose domicile was India at all material times, left India for Pakistan in July 1948, returned to India in December 1948 on a temporary permit and went back to Pakistan in April 1949. On 14 May 1953 she came back to India under permanent permit obtained from High Commissioner for India in Pakistan, which was cancelled on 12 July 1950 because it was wrongly issued without the concurrence of the government as required by the rules made under the Influx Form Pakistan Control Act 1949. She contended first that she had never ceased to be a citizen of India because she was born in India and her domicile was the domicile of her husband who was an Indian and consequently she was a citizen of India. She contended, alternatively, that the proviso to Article 7 applied to her since she had returned to India on a permanent permit and the subsequent cancellation of the permit was illegal and irrelevant. It was held that there could be no doubt that the lady must be held to have migrated from the territory of India after 1st March 1947, although her husband stayed in India, but she could not prove that she went to Pakistan for a temporary purpose. The Supreme Court observed, Article 7 clearly overrides Article 5. It is peremptory in its scope and makes no exception for such a case, that is, of the wife migrating to Pakistan leaving her husband in India. In an important judgment, The Supreme Court has held that those who had voluntarily migrated to Pakistan and became citizens of Pakistan cannot claim the citizenship of India on the ground that they had been living in India for a long time and their names have been included in the voters list. In this case, a lady Bhamvaru Khan had claimed Indian citizenship on the ground that she had returned to India in 1955 and had been living here since then. The court held that a foreign lady cannot claim Indian citizenship merely on the ground of long stay and inclusion of her name in the voters list.